Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's nicest indoor shooting facility, of course, that being Security Gun Club right here in Woodinville, Washington. Listen, we haven't had a chance to talk about this because there's been a whole lot of nothing going on, but there's a little bit of activity, and we do need to talk about Washington's magazine ban. Yeah, do you remember that? That happened almost 2 years ago now. Well, the thing about it is we've been so spun up with many other things, including our more recent assault weapon ban, and then all the things going on with the Biden administration, Department of Justice, and ATF. We haven't really had a chance to focus on that. We're going to talk to you about the case that was filed in the Western District of Washington, the case of Sullivan v. Ferguson. It appears that some new pleadings have been filed, and this does have the potential to be huge, but of course we also have to take into account the bench that we're arguing in front of. But it's definitely some fantastic pleadings. There is some hope here, and I think we need to talk about it. So today, let's spend a few minutes and let's talk about Hail Mary or Haymaker, another attempt to stop Washington's magazine ban. Okay, before we get going too far down the road, we are going down. Proud to announce that this video is being brought to you by Legal Heat. That's right, America's largest educator of concealed carry classes. Legal Heat has now taught over 250,000 people nationwide since they started doing this in 2005. Now listen, no matter where you are in the country, you can find a class anywhere near your backyard by visiting them at mylegalheat.com. That's mylegalheat. And listen, if you use the promo code Washington Gun Law, that's Washington Gun Law, all one word, you will receive 15% off. But for my folks here in the hometown crowd here in Washington, who no longer have very many freedoms at all, yeah, the folks at Legal Heat are abundantly aware of that, and they're going to do you a big solid, because right now, if you are a Washington State resident, find a class you like at any one of these locations, you go ahead and sign up and use the promo code WGLFREE, that's WGLFREE, all one word. Guess what? You're going to get that class for free. So that's whether you want to do a brand new beginner's class or you want to do some advanced training, anything that you like in the Legal Heat curriculum, you can do that right now for a limited time, absolutely free, by using that promo code WGLFREE. For more information, visit my good friends over at Legal Heat at mylegalheat.com. That is mylegalheat.com. Okay, so like I mentioned, the case we're talking about today is the case of Sullivan v. Ferguson. Sullivan v. Ferguson is one of several challenges to Washington's standard capacity magazine ban passed in the summer of 2022. It is filed in the Western District of Washington. Joel Ard, who we've had the pleasure of talking to on our channel on a couple of occasions, is lead counsel on that. So yes, this suit is in incredibly capable hands. What counsel has done here is filed a motion for summary judgment. Oh boy, that sounds big. It is big if it actually gets granted. What is summary judgment? Summary judgment is basically where one side files a motion with the court and says, hey, you know what? There really is no material dispute as to the facts. There really is no material dispute as to the law. It's all on our side, and rather than have a trial, why don't you just go ahead and enter a order and judgment in our favor. Now, do they get granted on occasion? They most certainly do. What's the likelihood of it occurring? Well, from a legal standpoint, is Mr. Ard on solid legal grounds? Yeah, he's on incredibly solid legal grounds. And has he done a good job articulating them? Yeah, he's done an amazing job articulating them. These are really good pleadings. We're going to share some of it with you. When we consider the bench, when we consider some of the rulings we've seen out of the bench, take a look at how they ruled on the injunction for assault weapons passed this year on Senate Bill 5078, well, you begin to see that no matter how talented of an attorney plaintiff's counsel may be here, we may be engaged in the act of throwing rocks at the moon. Now, one of the questions, of course, that the government will inevitably want to challenge is hey, these are magazines, these aren't guns. Do they even constitute arms altogether? Well, Mr. Ard was very well prepared for that, and his pleadings state as follows. Washington's magazine ban restricts the possession of arms. Of course, a magazine by itself is not capable of expelling a projectile, but neither is a firearm without ammunition, a rifle barrel, or a trigger. But regulations of any of these parts are obviously recognizable as regulations of the firearm itself. Magazines are no different. If the Second Amendment is to mean anything, then the Second Amendment's protection of arms must include not just complete firearms, but also component parts. And counsel went on to correctly point out, because magazines feed ammunition into certain guns, and ammunition is necessary for such a gun to function as intended, magazines are arms within the meaning of the Second Amendment. Though Washington may claim to dispute this, it must agree that restricting magazines effectively restricts arms, or else the state would have no plausible basis for regulating them. And that is a really, really good argument, because if they sit there and they say, well, magazines don't even constitute arms, then what is the nexus for your regulation of those magazines? And counsel points out that, listen, even absent that, there is additional case law and simple text from the Constitution that suggests that, in fact, magazines would constitute bearable arms. As counsel put it, even if this court finds a restriction on magazines is not the equivalent to a restriction on a firearm itself, and to be clear, that would be incorrect, it should still find that Washington's ban restricts conduct protected by the plain text of the Second Amendment. Constitutional rights implicitly protect those closely related acts necessary to their exercise. In this case, that means that the right to keep and bear arms must also protect the right to keep and bear the ammunition magazines that make those arms functional, since without bullets, the right to bear arms would be meaningless. And then, of course, since we now have argued that the plain text of the Second Amendment covers the possession of magazine and other feeding devices, the next question becomes, is there a historical analog? This gets us now back to the common use test, not announced in Bruin, rather announced in Heller, which basically says that, listen, we cannot ban firearms and other components which are in common use for lawful purposes. Put other ways, the only historical tradition that we have of allowing government to ban certain items are those items which are deemed dangerous and unusual. Now, granted, when we're talking about the most commonly owned magazines known to man anywhere on the planet, there is nothing unusual about that. As plaintiff's counsel points out, the magazine ban is a complete prohibition on commerce in ammunition magazines capable of holding more than 10 rounds. The Supreme Court has 3 times answered the specific question of what historical traditions of firearms regulations can possibly support modern-day bans on certain types of arms. Those cases establish that states can only ban arms that are dangerous and unusual. Magazines capable of holding more than 10 rounds are neither. And then, of course, plaintiff's counsel correctly points out that, listen, Heller, which has always been good law, was absolutely positively reaffirmed most recently in Bruin. As the plaintiffs put it, in Bruin, the Supreme Court reiterated that Heller's textual and historical analysis is controlling in this case. Bruin corrected more than a decade's worth of misinterpretation of Heller by the lower courts, doing away with the interest balancing regime that the circuit courts had developed in making the structure of Heller's text and history analysis explicit. A weapon may not be banned unless it is both dangerous and unusual. And then, of course, the argument is well, but you don't really use 15-round magazines, 17-round magazines in self-defense situations. And we've seen a judge down in Portland, not a particularly intelligent judge, fall into this in common use for self-defense. And then, of course, the question is what do you really need these things for? And when you argue with some of your more liberal friends, they will ultimately, that's their fallback position, is what do you need that for? Well, that's not how we define how our rights are exercised. But as Mr. Ard points out, furthermore, courts and legislatures do not have the authority to second-guess the choices made by law-abiding citizens by questioning whether they really need the arms that ordinary citizens have chosen to possess. And in Bruin, the court reaffirmed that the traditions of the American people, which includes their choice of preferred firearms, demand the court's unqualified deference. And then counsel does a really good job of going through the numerical value of approximately how many magazines are owned by Americans in the United States, which exceed 10 rounds. Of course, if you take a look at the numbers that the Supreme Court relied upon in Catano in determining that stun guns were in common use, well, then it's pretty obvious that magazines which exceed 10 rounds in capacity are far, far more in common use. As counsel put it, these statistics conclusively demonstrate that the banned magazines are commonly owned and used overwhelmingly by law-abiding Americans for lawful purposes. Indeed, the conclusion is so inescapable that courts throughout the country, including this circuit, agree that large capacity magazines are commonly used for lawful purposes. Okay, as I mentioned, this is a motion for summary judgment. Now, this is a difficult thing to do, okay? And so if plaintiffs do not prevail here, I don't necessarily want all of you hitting the panic buttons, but essentially you're asking the court to make a finding that there is no material dispute as to the facts, there is no material dispute as to the law, all of it favors plaintiffs, and therefore a judgment should be entered for the plaintiff sua sponte without conducting a trial. The likelihood of that occurring in the United States District Court for the Western District of Washington is not particularly good. But we are going to keep you posted because this is one of the many fights that we have to continue to fight all the way to the end. The case, once again, is Sullivan v. Ferguson. We're going to put links for all of it down below so you can check it out. In the meantime, if you have any other questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. Now, in the meantime, I do want all of you to remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.